Good morning, everyone, and welcome to Navigating Workers' Compensation Claims and More. I'm Vinny Civitello, Communications Manager for the New Jersey Business and Industry Association. With us today from Borden Perlman is Senior Director of Claims, Meg Errickson. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. If you just can't wait, you can download them right now from the Handouts tab, but I'd also like to draw your attention to the Questions tab. Meg would be happy to take all of your questions, so don't hesitate to write them in as they come to you. And I can't stress that enough, write them in as they come to you, or you may forget what you wanted to ask by the time we get to the Q&A. So now let's get things started. Meg?
Good morning, everyone. As Vinny stated, I'm Meg Errickson, the Senior Director of Claims for Borden Perlman. Borden Perlman is a full-service P&C agency located in Ewing, New Jersey. We've been in business since 1915, providing insurance services and risk management services to our clients. So I appreciate you taking the time today to learn a little bit more about workers' compensation. So I wanted to just give an overview of the objectives that we have today, that understanding workers' compensation can be challenging. So in this webinar, I'm designed it to just give you a brief history of workers' compensation along with an overview of the system, your premiums, the components that make up that premium and claims, and how that could potentially affect you in your experience mod. And then in the end, we'll be discussing how workers' compensation sometimes butts up against or collides with other laws such as the Family Medical Leave Act, the Americans with Disabilities Act, and pitfalls to potentially avoid employment practice liability issues. So I've put together the agenda, and what we'll talk about briefly is the history of workers' comp. What is workers' compensation and the components of premium, fixed and variable components. Your experience modification. What is an experience modification and how does that work against your program or for your program? And then workers' compensation claims, some of the components of the claim, some of the acronyms that we utilize. I think those are important to understand. Managing your claims, and then again, the FMLA, ADA, and the employment practice piece. And in the end, we'll have a question and answer session for anyone that has questions regarding anything surrounding workers' comp. So I love to give a brief history of workers' compensation. If I was live with you in the room, I'd ask this just to get feedback on what everyone thought the most noted portions in history of where workers' comp occurred. So I found it fascinating when I started studying workers' compensation to note that the first noted in history goes as far back as 2050 BC. Noted in the Nipper tablet number 3191. In ancient Sumeria, there was actually a system designed for injured workers that may have potentially injured a body part. In 1750 BC, in the Code of Hamburai, there was a similar system rewarding for specific injuries and permanent injuries. So for those of us that think that this is a fairly new system, it really is not. Again, in ancient Greek, Rome, Arab, and Chinese laws, they provided compensation schedules for losses to body parts. And so our system today is a more modern system. The modern system is credited to Otto von Bismarck of Prussia. This was the first system and the most important system because it started the social insurance process regarding workers' comp. And I do have a link in the end for those of you that are history buffs that can read about the history of workers' compensation in your free time. The United States passed its first Employers' Liability Act in 1906 and 1908. Prior to that, there were a few states that had passed those types of laws, New York being the first in 1898. And then the first modern workers' compensation system was passed in 1911. The state of Wisconsin passed it first. New Jersey also passed their law in 1911. And the final state to process that was in 1948, Mississippi. I will be speaking today specifically surrounding New Jersey, and I will not be going to the other states. So for some that may have a multi-state risk, some of the answers may be different based on the state law. So let's talk about what is workers' compensation. So workers' compensation, as I just stated, is a law in every state. So the concepts of workers' compensation are the same, but each state has its own specific law in how a claim is handled. New Jersey requires all employers to have workers' compensation coverage. So I've got a link below into the Department of Labor, which specifically talks about the entities and types of entities that need coverage. Even if you are a sole proprietor, you are still required to have workers' compensation. You as the sole owner may opt out of covering yourself, but you are still required to carry a policy within the state of New Jersey. It's designed to protect the employee and the employer when an employee is injured at work. It provides benefits for the following: medical benefits. So those medical expenses include everything from doctor's visits, physical therapy, diagnostic treatments such as MRI, your prescriptions. It provides coverage for lost wages. So if an injured worker is unable to attend to come to work on a daily basis, we provide for the lost wages of that employee during that time. Permanency awards. This is something we'll discuss a little bit later, more in depth. A permanency award is a system designed that if you injure a body part, you're entitled to an award specifically surrounding that body part. It provides death benefits to injured workers' families in the event of a death. It provides legal expenses in the event that the legal system is involved where an employee secures counsel. And there's two components to a work comp policy. One is Part 1, workers' compensation, which is what we'll be discussing today. And the second portion of that is the employer's liability section. This is a section where an employee could opt out of workers' comp as their sole remedy and decide to sue an employer for gross negligence. But for today's purposes, we're going to discuss Part 1, the workers' compensation portion. So what are the components of workers' compensation premium? So when you get your premium from an insurance company, there are things that go into your premium that are what we call fixed components. I often hear consumers say to me, well, there's not much you can do with workers' comp. The rates of insurance are set by the state. Your payroll's your payroll. So let's talk about what the fixed components are. Classification codes. The state of New Jersey puts each employer into what we call a governing class code. That class code is designed for employers that each employer of your type is got a governing class code the same. So if you are a business office and your governing class code then may be clerical of 8810. If you're a manufacturer, you may have a different code. You may have some payroll assigned to some other class codes, but they'll pick a main governing class code for the type of business you are. Within your business, each function of a job has then a classification rate. So the state sets the rates every year. And so depending on how each class of business does over a historical period, they decide what is the rate of insurance needed to be charged for each $100 of payroll. And then your payroll is your payroll. It's important when you're submitting your payroll information to the auditors that you make sure all of the payroll is allocated to the proper class code. So I usually use the example that if you are a warehouse and you have a warehouse manager that sits in an office and only does paperwork every day, managing the warehouse, that warehouse manager, while you may have him in your payroll as assigned to warehouse, he's technically clerical under 8810. So when reviewing things with your auditors, make sure your payroll is allocated properly into the proper class codes based on the job function they're performing. And then there are state surcharges. Those are all fixed things that are within the components of premium. We then have a variable component, which is your experience modification. And we're going to go a bit into what does that mean and how is that calculated. That is a variable, and depending on the information contained in your experience mod, that's an area where you may potentially be able to make impact to your overall program. So what is an experience mod? An experience mod is a factor that's set by the State Rating Bureau. Here in New Jersey CRIB is our state rating bureau. We have our own state rating bureau. Some of you with a multi-state risk may have heard of NCCI. NCCI is a national conglomeration where they have maybe multiple states they pull together. But we in this state have our own rating bureau for New Jersey specific business. The rating bureau is the one that determines the loss factors for each class of business and the class code. They are the ones that compare your payroll and loss data to a company of like kind and quality. So your company is compared to your competitors' companies, and that's all done through payroll and loss data. And they calculate your experience mod using historical loss data. So for example, if you have a rating of a 1 is the base rate for any business. So if you were new in business, you would start out with a class code of 1. If your loss data and payroll data put your rate at a 0.9 for your experience mod, that would mean that your risk is running better than those in your class code of a business the same type, and you would get a 10% discount off of your premium. If your losses were higher than the expected loss factor and your mod was a 1.1, your premium would be 10% higher. And that's calculated using historical data over a 3-year period. And so that credit or debit adjustment in your workers' comp program affects the premium. So I put together a chart here. It's a little bit complicated to understand how your mod's calculated, but the carriers the state looks at a 3-year look back of your losses and payroll data. So in this example, if your policy just renewed on January 1st, 2020, the insurance carrier and the bureaus take all of the data from January 1st, 2016, January 1st, 2017, and January 1st, 2018. They give that information to the state of New Jersey, and the state of New Jersey calculated your experience mod based on data fed to them July 1st, 2019. So when you just received your renewal for 1/1/2020, if you got an increase in your experience mod, that increase actually happened with loss data fed to the state of New Jersey back in July. So it's key to understand what we call your unit stat date, because it's important to make sure that your loss information going in is at the bare minimum that it should be for reserves that may be outstanding on a claim. So if your mod went up, the only thing you could actually retroactively correct it for is for 4 reasons. So it's important to understand the dates and when your mod is calculated. You actually could get what's called a projected mod. If someone had the data regarding your losses and your audited payroll and put the calculations together, there's various software programs out there, they could actually project your mod in July as to what your upcoming renewal should be. So there should never be any surprises. You don't have to wait until the state of New Jersey assesses your mod before you know what the upcoming renewal is going to look like. That data could always be taken and done. So the next slide is, when I said there's only 4 reasons that you can retroactively go back and correct this, I do have the quick fix button here. I should have put a giant X over that, because there is no quick fix, even if you do find that there's a problem with your experience mod. So if the insurance carrier, for some reason, fed data to the state that was incorrect, so your claims data was incorrect, or your payroll information that was audited was incorrect, that is one reason that you can retroactively go back and have a mod recalculated. If a claim is found to be fraudulent, so that would mean that the individual putting the claim in was found to have perpetrated fraud, oftentimes that has to be decided by a comp bureau judge, or the claim gets withdrawn by the employee, that claim could be removed from your experience mod retroactively. If the injured worker pursued a responsible party and received a bodily injury settlement. This one is one that often clients get confused on. So for example, say I have an injured worker, they're a salesman, they're out on sales calls and they are rear-ended by a car and they're sustained an injury. That employee is entitled to workers' comp because they're working at the time the auto accident occurred. The injured worker may decide to file a bodily injury claim against the responsible driver that caused their injury. If they're successful in collecting from that responsible party, the workers' compensation carrier will have placed a lien on that money. They're entitled to 2/3 of the settlement money to pay back the work comp claim. So if you had a workers' comp claim that was $100,000 and the employee received $200,000 from the responsible party, they owe back $75,000 of that claim to the workers' compensation carrier. You can't collect from both. Workers' comp is a sole remedy. So there is an ability for you to claim back monies if the employee chooses to pursue someone. However, there's a period of time that takes. So it's not a quick fix button, as I said here. But if that does occur, then you could retroactively go back and get that taken off of your experience. The injured worker also, if they're awarded what we call second injury fund. Second injury fund is a law that was established here in 1923, which would encourage people to hire workers that may have an underlying disability. If a person that has a qualified disability that then has a work-related injury, that puts them out of work and they're now 100% totally disabled. That claim can be sent over to the second injury fund. They have to apply for second injury fund on their claim, and they'll receive their benefits from the second injury fund, and the workers' compensation carrier is not affected. Again, it's a process that happens, though, in order for someone to apply for second injury fund in a time frame. And so therefore, again, not a quick fix button, but these are the only 4 reasons that a mod can get corrected retroactively backwards. So it's important when an experience mod is being calculated that the data going in is appropriate and correct. So here's where I have how your expected losses and your actual losses equal your experience mod. So if you look on the top part of this chart, the variable we have is what are the outstanding reserves on your open claim files. That is something that if it is not accurate and a reserve is set too high and it goes into your experience mod calculation, you're actually paying more than you should in your experience mod. And it's a variable component that can be changed prior to that unit stat date or the experience mod calculation. So the expected losses will always be what your experience mod is calculated against. So if your losses are higher than that expected losses that the state has set, you will pay a debit mod. And if your losses are better than the expected losses, you'll have a credit mod. So let's go into what are the components of a claim now that we've talked about your premium and experience mods, and we can understand a little more about claims and then some of the things that you can do to potentially make impact to the values of those claims. So the components of the claim that we have, especially when reporting a claim, it involves the date that the loss occurred, the date the accident happened, the nature of that injury, what are the medical costs, the lost time cost, the permanent injury cost that may be set aside, the legal expenses, and your general expenses. General expenses on a claim can be anything from nurse case managers that may be brought in to assess a claim. Those are some general expenses the insurance company pays that aren't assessed to medical or to legal. The next chart I give is one thing about workers' comp is I don't know why, we speak in acronyms. And if you've ever had the opportunity to potentially read an adjuster's report, you may see a lot of these terms. So for someone like myself who's dealt with workers' comp for a long time, I could actually call an adjuster and say, hey, how long have they been OOW and what is their PPD and when do you expect them to be at MMI and RTW? Now I basically just asked, how long have they been out of work? When do you expect them to be back at maximum medical improvement? Do we have permanency up on that? And the RTW, when are they going to return to work, right? These acronyms are common. You'll see them in claim notes if you have access to the adjuster notes at your carrier. You will see treatment, we call TX, surgeries noted SX. We don't speak, for some reason, write it out. It may be easier, but I think as a consumer of the product and understanding your claims, if at any point in time in the claims process you don't understand anything, that it's always important to ask. You know, if you get a call from the adjuster and they say, hey, we're going to put an NCM on that case, see, in their mind, they know what an NCM is, but I don't think many people would understand that we're going to be assigning a nurse case manager to work with the employee and the doctors to try to get the employee back to work or to understand the ongoing medical treatment. So let's see, what do we do when we manage a claim when it occurs? This is important that you have a plan. What is your injury reporting process? So do you have a process where when a worker is injured that you have protocols in place to assist that injured worker? Research has shown having protocols in place on what to do actually helps the claim results in the end. Directing medical treatment. In New Jersey, you as the employer have the right to direct the medical treatment of the injured worker. I often recommend to clients that if you have a local 24-hour emergency med or concentric care, rather than always relying on the emergency room, you could actually work with those centers to become your first point of contact for any injured worker. Where that may benefit you is one, they may potentially be in network on the carrier site. Most carrier sites, if you go on them under workers' comp, you can actually access who are the doctors approved in the network. You as the employer do not have to choose any of those because you have the right to direct treatment anywhere you choose. The carrier may change treatment or attempt to change treatment once the claim is assigned and moving, but you have the first point of directing treatment for the employee. So it's always good I had a client once that they were a beer distributor. They actually had contracted with the local physical therapy office near their facility, and they had kegs of water that were brought to the physical therapy place. So as the injured workers were rehabbing, they were actually rehabbing with items that they would be using in their physical facility. So when you have those relationships, it's good to always know what's your medical treatment. It's key to get that employee to medical treatment before you do anything else. Completing the first notice of loss. This is an important thing that should happen timely. It should include everything from date and time, witnesses, location, nature of injury. These forms are often required to become completed by human resources. Many carriers have online ability to complete the form online. You may have a written form that you like to fax or email. The form requires you to have the employee's date of hire, their social security number, their date of birth, the number of dependents, their annual salary. Usually having human resource or whoever handles your employment matters are the ones that complete these forms. So making sure you have a process to know who completes the form and how you get it to the carrier is important. Your accident investigation. So if you're a small company, you may just have a simple accident form to understand what happens. So when the adjuster calls you, you can record that information in live time. It's often important to capture the information as an accident occurs because over time, details tend to deplete. Determining compensability. Once all of the information is sent to the insurance carrier, they will determine the compensability of a work-related injury. If at any point in time in the beginning of the process you have concerns that the injured worker reporting the claim may not be telling the truth or you have any concerns, certainly red flag that for the carrier so they do their full investigation because that's part of determining the compensability. If it is a simple, I always say if it's a simple, I lacerated my finger on a knife, it's normally compensable and going to be accepted very quickly. Sometimes the more challenging ones on compensability are, someone comes in on Monday morning and very quickly says they strained their back or hurt their knee. You may be concerned something occurred over the weekend, and you should always let the adjuster know that you have those concerns. Is the employee losing time from work? This is also a key thing to make sure on the upfront that you let the carrier know the employee is losing time from work. Part of the reason is most carriers take in claims initially and send them to what we call a first level adjuster. Those adjusters are normally what we call medical only adjusters, and their role is to handle the medical portion of the claim. If an employee is losing time from work, that actually belongs with what we call a lost time adjuster, and that needs to be moved. So to try to avoid having claims moved in the early onset from adjuster to adjuster, which can be disruptive for the employee because they'll be contacted by more than one person, it's key to let them know the employee is losing time from work. Communicating all of that information to the adjuster as well is something that is important. Making sure that you give them all of the details, any concerns you have, on the upfront. They will call you first before they contact the injured worker to get all of the information in details of anything that you have and anything that you may need before they contact the injured worker. Communicating with the employee. This is something we think is important. Employees want to know that, that you know and care about them. We are still human beings. And so communicating with the employee while they're out of work and while they're injured, giving them direction, oftentimes will keep them from going to an attorney potentially on the onset. Doesn't mean that an employee won't ultimately go to an attorney, but they might, and they have the legal right to, but communicating with them and keeping an open dialogue on how they are and what's happening is important. And then return to work. There will always be a plan in returning to work. So when an injured worker is out, internally you need to assess whether or not you have a return to work program and are looking potentially to bring the employee back to work in maybe a light duty capacity or at any point in time. So once a claim is established, the management of that claim and the details of it can differ greatly. So it really depends on the type of claim and the information regarding the injury. So maintaining an open dialogue with the adjuster and the injured worker is important. If you have someone that is out losing time, it's important to understand why is that individual out losing time, what is the medical care they're having, and when do you anticipate them returning to work. Providing necessary documentation as the claim goes on. I would say the second one I have here under examples is the wage statement form. I often get calls from carriers that they're having a hard time getting the wage statement form from the employer. Why it's important to get the wage statement form is the wages that the employee is paid are based on a 26-week look back from the date of the injury. And it's based on an average of what that 26-week payroll is for exempt versus non-exempt employees. That can be different because there can be overtime paid to hourly workers. And so they will calculate that using the last 26-week look back. If they don't get the form, there are certain time frames that the carrier must issue these payments. And so sometimes without the wage statement, they may project too high based on information they have, and they'll have overpaid the claim. They can't take a credit back for that unless the employee is getting an award later on. So it's important to get the wage statement to the carrier as soon as possible so that they're actually paying the employee at the rate that they should be paid. Medical management. Most carriers will follow conservative guidelines that are established by the AMA. So if an employee is undergoing conservative treatment, maybe the orthopedist has sent them for physical therapy, they go through their 6 weeks of physical therapy, that's not happening. In the medical management process, it should move to what diagnostics are next, are they getting an MRI, so we can understand what's happening within the body. That whole medical management piece, you are entitled as the employer to all medical information with regard to the injured worker. There is a HIPAA carve out in workers' compensation. When HIPAA was being established, the workers' compensation carriers were extremely vocal in the process that there needed to be a carve out surrounding workers' compensation. And there is a carve out specifically for the reason that if this worker has injured that body part previously or at another employer and has been paid an award, that the current carrier needs to know. Or if they've treated for this body part and this is a pre-existing condition, the employer needs to know. So the medical management piece, you're entitled to everything happening medically with regard to this employee. So let's talk about employees that are losing time from work. When an employee is losing time from work, they are entitled to lost wage benefits paid for by the workers' compensation carrier. For this year, 2020, and every year this rate changes. In the resource section below, I do have a link to the New Jersey Department of Labor section where we have from 1997 to 2020, what is the rate that the employees are paid. So for this year, if you are an injured worker, you get 70% of your average weekly wage, that's the gross wage, to a maximum of $945. So if you're a worker that makes $52,000 a year, that's $1,000 a week, you would receive $700 tax-free for your injury. It is a tax-free dollar. They take 30% off, which is the projected amount that taxes and Social Security would pay. And so therefore, that worker would be made whole. Now, if you were a worker that made $2,000 a week, you would still only get $945 a week. You would not get the $1,400 that is your actual take home of the 70%. So a worker that makes more than that $945 may be receiving less money under workers' compensation. You are not required to pay the differential between the two. Sometimes it's an incentive to get people back to work. Some employers may, within their employment and their employee practices, pay the difference between that. It really, you would have to defer to what are your employee protocols. It's also important to note the minimum number that we have here in New Jersey. Sometimes this is if you have a part-time retail worker that makes less than that, they may be making more under workers' compensation while they're out for an injury. So it's hard to get them back to work as quickly as you'd like because they make more money on workers' comp. They're the ones that are not so disappointed to be out on comp because they're receiving more money. But that's the minimum that's allowed to be paid to them on a weekly basis. Some of the things to consider when you have an employee out losing time from work is, do you have a light duty policy? Is there light duty available? In that medical management piece, the doctor should be assessing what is the capabilities of the injured worker and are they able to come back in any light duty capacity. If they are out and you're unable to accommodate that, when is the anticipated full return to work date? All doctors will note to the carrier when they believe, and the carrier will also have noted a full duty return to work should be allowed. And that's based on information they have of similar claims. They pull a number that should be the anticipated full duty return to work. And is the employee being compliant with medical treatment? If the employee cancels more than 2 appointments, the insurance companies normally will stop paying the lost time benefits because the employee is non-compliant. And what it's always good to ask the carrier, if you have a non-compliant employee, what are you doing to try to get them back to medical treatment so they can get back to work? Accommodating light duty. So this question happens all the time. So say you have a forklift operator, and that forklift operator can no longer operate a forklift while they're injured. And it says they have to have sedentary duty, no standing. It has to be completely sedentary. Can you accommodate that? So if you could accommodate them doing something else for the organization, maybe sorting paper clips in the conference room, shredding papers, anything that you have that they can do, bringing them back on light duty is normally recommended. One, it keeps them from being at home with little to do. It also gives you the ability to lower those numbers, as we talked about, that are standing out in reserve on a claim. If we have to hold reserves and continue to pay them for that weekly lost benefit, bringing them back light duty brings them back to your payroll and eliminates some of that portion of the claim. There's also new trends for what we call reemployability. So you can always ask your carrier if there are any what we call reemployability companies. So if you as an employer can't accommodate light duty, there are companies now that contract with nonprofits that can put the worker into a nonprofit situation to assist that nonprofit within the scope of their light duty restrictions. So if you contract, so say for example, the American Red Cross needs workers that can sit and take out the expired first aid cream from their kits and put in new first aid cream from their kits for national disaster purposes. You would pay the employee, but on a daily basis, they would go to that nonprofit and perform the job there. That's another way to avoid, if you can't accommodate light duty, is seeing if the carrier has any reemployability companies that they recommend. Again, you would pay their salary, they would be doing work, but work for someone else, and it would be work for a nonprofit. So it's a win-win. The judges in the court system have felt that this was a good way to get injured workers on light duty doing something and have been very favorable in that aspect. Understanding the reserves. So those variable components that make up your mod, understanding what those dollars stand out for. It's oftentimes those numbers may be held out and they're incorrect and the adjuster just hasn't closed them down. So it's important to understand and get a breakdown of what that reserve represents. There should always be a reserve for the medical treatment. There should be a reserve for the what we call temporary benefits. That's the lost wage component. And there should be a reserve for what we call permanency. Permanency, and we'll get into that process in a bit, is how your body is placed on a chart and you're entitled to an award. So understanding the components that make up that reserve is important, and understanding whether those numbers are correct is important. There's many claims I've reviewed where an injured worker is back to work, is no longer medically treating, and we're waiting to finalize that permanency piece, but there are outstanding reserves for the medical and the lost time. It's key to make sure the adjuster closes those reserves down so that they're not affecting that variable component that goes into your mod. Accommodating permanent restrictions. This question's come up for me from several clients in the past couple of weeks where the employee has treated and reached what we call maximum medical improvement. You will hear that word if you have a comp claim. Maximum medical improvement is the point in time where an employee can no longer receive any additional medical treatment that's going to change the situation that they're in. So there'll become a point in time where they've done everything medically and the employee's at the maximum of what they think they will ever be medically. At that point in time, sometimes the carriers will have what's called a functional capacity exam done. That functional capacity exam is done to see what is the functional capacity this employee can do. So if they were in a heavy manufacturing job and they had a significant back injury with back surgery, they would normally put them through a functional capacity exam to see, is that injured worker, now that they've had back surgery, able to function in the job function they had prior. If they're unable to do that job, and it's recommended that they never do that particular work again, that employee may get what's called a permanent restriction, where they permanently cannot do that type of work. You, as an employer, the same with light duty, have to determine, can you accommodate a permanent restriction? Do you have something else that they could do that would allow them to be able to come back to your employment? You are not required to accommodate permanent restrictions in New Jersey. So unfortunately, at that point in time, the decision has to be made. If you can't accommodate the employee has other options available to them. They would go on unemployment if they can't stay within your employ. They could apply for Social Security, disability, but you're not required to accommodate a permanent restriction for an employee. That's what permanent restrictions are if they're assessed. Let's talk about the permanency process. This is one seems to be painful for a lot of employers, but if you think about the history I gave back in 2050 BC, they had a system that did exactly what we're going to talk about here. So for example, for the year 2020, and I do have a link below, if you look at item 4, this is the link into the charts that are available where your body is actually put on a chart every year. So effective this year, 2020, your arm, if you were to have lost your arm at the shoulder, the state of New Jersey has assessed your arm to be worth $228,690, or what we call 330 weeks. So they would divide that number by 330 weeks, and you would receive that check every week for 330 weeks. In this process, however, the system also states that if you injured that body part is no longer 100% of what it was prior to the work-related injury. So I'll use the arm again as an example. So say I fracture my arm. It's a simple fracture, didn't require surgery, no pins available. I treat, I'm returned to work. Now we go through the permanency process. The treating physician that treated me for the loss says, Meg is 10%, her arm is 10% of what it was, 10% less than what it was before the fracture. I would be entitled to 10% or $8,316 over 33 weeks for that particular arm. What happens is if I had an attorney, the insurance carrier's doctors may say her arm's 10%, and they may send me through, and my attorney, the doctors my attorney sent me to may say my arm is 45% of what it was. And then they would send me through what's called an IME or an independent medical exam, and they would have a third party decide what that arm was. And then somewhere in between the 10% and the 45% would come through the court process a decision on what my actual permanency numbers are. And then you would go to the chart and it would tell you how much that was worth. So that is the permanency process. It is a longstanding system that's been in place in every state, not really a way to get around it, one that is pretty much a barter back and forth using the facts of the medical community. So I wanted to talk a bit today about some of the colliding laws to consider. Certainly down here in red, I have it that I am not an attorney, and this is not to provide any legal advice to anyone other than to state if you are coming up against any of the challenges with returning people to work and how you handle things, it's important to make sure that you refer to your HR protocols, to your employee handbooks, that you speak with your qualified HR representatives or the attorney that you work with regarding any human resource matters. I've often gotten the question, Family Medical Leave Act, how do we handle workers while they're out on workers' compensation? And that really goes back to what does your protocol say? FMLA was designed federally in 1993 to protect workers, to give them job protection of 12 weeks. In New Jersey, we do have a paid system as well, and it provides up to 12 weeks of job protection. It can be run concurrently with workers' compensation while employees are out on a work-related injury. You would have to handle that FMLA the same way you handle any other disability, medical disability, and that is making sure the proper paperwork and things are sent to the employee. So it's important that you know what your protocols are, whether your human resource department or your employee handbook say, any work-related injury or any medical disability, including workers' comp, that FMLA applies. And then you would follow that, but FMLA can run concurrent with workers' compensation. Another area to consider, and I have provided a link here to the EEOC, the Equal Employment Opportunity Commission, which speaks specifically to workers' compensation and the ADA. The ADA is a civil rights law that established equal opportunity for people with disabilities. So I always give this example. So say I am out on a workers' compensation claim. I work for a large employer. They have 250,000 employees that I am one of. And I have been out on workers' compensation for 12 weeks, and I know my FMLA job protection is coming to the end. I may send a letter to my employer to say, under the Americans with Disabilities Act, I'm requesting you provide me with a reasonable accommodation of the 4 more weeks my doctor is saying that I need. See, again, you can see how these laws can butt up against one another. If I'm a large employer, I might be hard pressed to say that we as a large company with 250,000 employees, that it would be a hardship for them not to accommodate that additional 4 weeks that I'm asking. So again, these are things that may come up. It is the employee's responsibility to ask for those accommodations. You don't have to seek those out from the employee to say, hey, let's look to see if we can accommodate you. They have to ask. So if it was a small employer, it might certainly be a hardship for them to have me out for another 4 weeks if I served as a critical component. Even in the organization where there's 250,000, if I was one person of 250,000 that did one critical component job and there was no one else, it could be a hardship for them. They would have to demonstrate it's a hardship to accommodate. And then I have here employment practice liability insurance. This really is the insurance that covers over the Civil Rights Act of 1964, which is the discrimination against bias, race, color, religion, sexual orientation, sex as a whole, national origin. Employment practice liability insurance is one that covers over that civil rights law. I have seen cases, unfortunately many cases, where an employee may file with the EEOC to say that they were terminated as a result of a workers' compensation claim. That has to be defended on. So, the employment practice liability insurance is the one that would respond to that. So in the event that an employee, is let go and let go properly, doesn't mean that they can't file with the EEOC to say that they were terminated improperly. So I thought it was important to talk about some of the areas where, because workers' compensation is a law, and then you have these other leave laws or protective laws, that it's important that you understand that when you're making decisions with regard to potentially terminating, not accommodating restrictions and things, that you do work out with your HR representatives or your attorney on the best way and manner in which to handle that. So for today's purposes, that is all I have for you. I'm going to turn it back to Vinny, and I think we're going to open with any questions anyone might have. I know this was a lot of information in a very short period of time, so certainly if you have any questions after this, I'm certain there'll be a way that you can certainly ask that as well.
Thanks, Meg. Yeah, we have a few great questions in already. Don't worry about the time. I know we're coming up on the 12 o'clock hour. If you've got a meeting, if you've got lunch you got to get to, and this runs over, by all means, feel free to go. Everyone who registered for this webinar will be receiving a recording of it tomorrow, so you won't have to feel like you're missing anything. But while we're waiting, I just want to give everybody a chance to type in anything they have. I'll remind you about the handouts tab. A lot of the questions that we get are asking me how we download the PowerPoint slides. So by all means, just go over to the handouts tab and you'll see it there, WC Webinar PPT. And then there's the questions tab. If you have a question, feel free to type it right in there. Meg will answer it. And don't be shy. You've got an expert here, so feel free to take advantage of her. I read all of the webinar evaluations that you guys fill out. I can't tell you how disappointed I get when somebody says like, oh, I thought she'd talk about this, or it was too in the weeds, it was too broad. This is your opportunity to take it in the direction you want it to go. So with all of that out of the way, let's start with Erica's question. If you have a new business and have calculated wages, but at the end of the year the wages are significantly less, can you request a modification?
So if you're a new business and you're starting out as a 1, that's where all new businesses start out as, you wouldn't have any expected losses in which to compare that to. So requesting that likely would not make any change in what you were asking. So I think if it was an established business, when you do your audited payroll, that's where you get the premium differential based on the premium you've paid. And then that goes into the state bureaus. The state bureaus base it on the audited payroll for the years. That's why there is that quote unquote, what we call lag year. When you look at the slides, if you go back to where I had it, it's 16, 17, 18. The current year is not calculated into that factor. And that's because that information is what we call green. And so they don't utilize the current year in that factor. So hopefully by the time that full year plays out, the information is all audited and correct, and it should be appropriate with how that's calculated.
Great. We have one from Neil who asks, do you foresee workers' compensation claims arising out of the new coronavirus, such as possible contaminated surfaces at work by sick appearing customers or members, or not enough protection provided by the employer?
Great question. You know, coronavirus came up before I was on my way here to the office, and we had a very similar question. I think when we get into any kind of occupational illness, it would come down to what is the exposure, how was the exposure? Viruses are very challenging to point back to a work comp scenario. Because people are out in the general public, you would have to, I think, demonstrate from a compensability standpoint that the employee was only at your employee and that there's no other place that they could have absolutely gotten that particular virus. Very challenging to prove. They certainly could say that, and I always recommend to anyone that anytime anyone believes that their claim is work-related, whether it is occupational, they ended up with the flu, coronavirus, I would say, I think likely it would be one of the claims that the carriers would deny just based on the facts of the claim. It would have to arise out of the course and scope of your employment and very challenging to prove.
Okay, Roseanne asks, where do you find the list of in-network providers?
So depending on the insurance carrier that you're with, if you're on your insurance carrier's website, there should always be a section that says workers' compensation. Sometimes within your policy, it will give you a link to your preferred provider network. You're not required to utilize their networks. I would say the benefit of using the network is that it is doctors that have been contracted that on top of the medical that is being paid, there is additional discounts. I will state that most people think the insurance company contracts with these doctors. They do not. They're not legally allowed to, but they do contract with outside third-party companies that build networks the same way that your health carrier does. So it could be a First Health or a Concentra or a Health Net. They contract with various networks to receive additional pricing. So if it's not on your carrier website and it's not a link in your policy that provides that to you, I would contact your agent or broker and have them provide you with where you can obtain that information. They should be able to provide you with a list.
Another one from Roseanne who asks, how long do you have to submit a claim from the date of the injury?
So there is a 2-year statute of limitations in New Jersey that claim must be reported. Timely reporting is one of the areas a claim can get denied. And so we think it's important. Research shows the minute that someone alleges something happened at work, it's best to put it in so the investigation can happen. Carriers, from an underwriting perspective, they do note the length of time it takes an employer to get a claim to them, and they will look at that overall in your program because research has shown the faster they get a claim, the easier the impact is from a positive for the employer. They can actually engage in the claim very quickly and the dollars are less. So it's important to get it to the carrier as soon as possible, but there is a 2-year statute of limitations from the time an injury occurs for an actual injury. Occupational disease or someone that says that they contracted a disease over a long period of time or degenerative condition is different, but it is a 2-year window.
I actually had a quick follow-up for that. So speaking of date of the injury, on your list of acronyms, there was date of injury and date of accident. Is there any difference between those two things?
There is not. The date of injury versus date of accident, each carrier chooses. I put them both on there because some carriers may have a DOA and some may have a DOI. Unfortunately, they don't utilize the same terms.
Gotcha. Another one from Neil who asks, how do employers communicate with the doctors or workers' compensation insurance about which duties may no longer be suitable for the worker, such as a physical instructor demoing certain moves and ending up getting re-injured for the body part due to inappropriate moves?
Great question. So each carrier should send to you, and you can request it if you don't get it, that there's a job assessment done. So the employer fills out what job requirements there are. Before that employee goes to the doctor, they should have a full outline of what the full job entails, whether it's lifting, bending, twisting, the amount of pounds necessary. They're pretty comprehensive forms. And while it takes probably some time to complete it, it's important to complete it so the doctor evaluating the return to work understands completely what the job may entail. Ultimately, the doctor is the deciding factor because they're the experts in medical. And so based on the job description and the limitations and things required, they should be assessing that in the current condition that the employee is.
Here's another one from Roseanne who asks, the permanency process, is that something that applies all the time?
Permanency is not something that applies all the time. Permanency, so for example, if you have a simple finger laceration, likely the doctor would assess you at 0% permanency and there's not a permanency process. The employee, however, could retain counsel and determine that they may want to be entitled to permanency, and then it would go through the legal process through the workers' compensation courts. So it's not always, the doctor will always assess permanency. However, on simple medical only claims where there is no lost time, often they don't assess permanency. However, you could have a fracture and have no lost time and only receive medical only because the employer could accommodate you, and you would be entitled to permanency. So each case has to be looked at on its merit, but if someone is seeking permanency, the carriers must evaluate that.
Here's one from Sue who asks, how long are employers required to maintain health insurance for an employee on workers' compensation?
That is something you'd have to check with as an employee. If they're entitled to health benefits, you would have to check with what your employee manual states in the event of absence. I know oftentimes employers have a contribution that the employee does contribute. And when an employee is out on workers' compensation, you should follow that process the same. So, for example, if the employee is receiving, if they're $1,000, as I indicated before, and they get $700 a week, and they're supposed to be contributing $200 towards their medical, you need to, as the employer, if you choose to, I mean, you don't have to, if they're contributing and you want them to still contribute, you have to set up the mechanism for them to still contribute towards their health program. They, I'm assuming if they're still in your employ, even if they're on workers' comp, that you would still continue their medical benefits because they are an active employee.
Rivki asks, what would you recommend doing when you are certain that an employee filed a fraudulent claim? You know the injury occurred during non-working hours, but your workers' compensation carrier decides to pay out. Is there any way to contest that?
Once the claim has been accepted, it's very hard to contest that as the employer. Again, that upfront process of understanding why a carrier is accepting a claim is important, and staying engaged in the claim is important. If there's information that you have that states the employee was injured out of work and you heard that from a witness that witnessed it, it'd be important for the insurance carrier to speak to that witness in order to try to deny the claim. I will say that it is called workers' comp, and the courts tend to be very liberal towards the injured worker, but if there's information, it should certainly be part of the investigation. And if a claim is accepted, you as the employer should completely understand why and what's the rationale behind accepting that.
Lauren asks, can my workers' compensation insurer assess my 1099 workers?
So if you are have employed 1099 workers and they do not have their own insurance, they are technically your worker. Let me finish that. Sorry, that was just took a sip of water. The reason for that is when you do your audit, they will look at the certificates of insurance that you may have for a 1099 worker. If that 1099 worker cannot demonstrate and you cannot demonstrate they have their own workers' compensation, they technically are then an employee of yours, and that payroll is assessed into your workers' compensation mod. So if they're injured while performing work for you, whether they're a 1099 or a payrolled employee, that work-related injury becomes yours.
Cool. Jennifer asks, who decides what New Jersey codes to use, like 8810, for each position?
So when the auditor comes out, you have to put the payroll into what the function of the employee is. It should certainly be an open dialogue with the auditors when you're submitting the payroll. So the example I gave with the warehouse manager, if their payroll's assigned to warehouse, but you move that payroll into clerical, you would need to just explain to them why you believe it's 8810. If there are arguments to be made against that particular coding, we as agents, I know at Borden Perlman, if a client has any concerns or questions about their audit, we will certainly work with the carrier and the auditors to determine and understand why payroll's assigned to certain class codes. It's done by the auditors. The class codes that you're assessed with, if you think they're incorrect, especially your governing class code, there is a manual on the NJCRIB website which explains class codes and what those actual functionalities are. So if you have any questions or concerns about the class codes, you can go to the NJCRIB website, look at the manual for class codes and read what those codes are. If you feel they don't fit your business, you can certainly talk to your broker in the bureau about seeing if you can get that changed.
Okay, I got a couple more here, but feel free to keep them coming. One is from Danny, who asks, who is responsible for making sure the reserves are correct on a workers' compensation claim?
Oh, I get this question often. So it's a tough question. You know, at Borden Perlman, we have a qualified claims team. It's our job, we feel, to make sure that the reserves assessed on a file for each of our clients, that they understand the reserves, whether that is a work comp claim or any other type of claim. We are experienced in all things claims, and so our understanding and our ability to explain the reserve to you is important. I would say I would speak with your agent or broker if you have questions on reserves and see if they can help provide for you the information. If they're unable to, the carriers can provide you the reserve information. I would say, though, that understanding the components of a claim, that's from the carrier's perspective, that having somebody that's independent of that can review it might be important.
Roseanne asks, with regard to your example of a warehouse manager, when determining the workers' compensation code for an employee, what percentage of time does an employee need to be performance desk work in order to determine if their job is more administrative?
Great question. I think that it's important to have the conversation with the auditor. I'm not certain that a percentage applies. I will say in the example I gave that if you find 50% of the time the warehouse manager is actually physically out in the warehouse manning fork traffic and all of those things, they likely will be assessed in the warehouse code. Because they're in the warehouse and the exposures to being in a warehouse is greater, you'd have a harder time putting that person into clerical if the larger percentage of time they may be within that warehouse doing work. If they solely sit in an office and they're doing the payroll and they're doing the billing and they're doing the logistics of a warehouse and they don't enter the warehouse on a frequent basis at all, that would be a good example in which to try to get that payroll allocated to the 8810 code, because the majority of what that employee does is clerical. So again, it's a discussion when the auditors come in. I know many people don't like to be audited and spend time with the auditors, but they actually are doing a critical function within your mod, that it's important that the payroll is allocated where it needs to be.
Charles would like to know, when the insurance carrier incurs and pays general expenses but does not pay any medical or indemnity, does this general expense affect the mod?
Great question. Expenses are not part of the mod calculation.
Elizabeth asks, what's a Section 20?
Section 20. So within the workers' compensation law, and with every law in every state, there is a section of the law that says we may settle a claim that we think has no compensability and without admission of liability. Section 20 is the law, portion of the law within New Jersey where if we feel there is no compensable accident, but going through the litigated process to potentially end up with a very large claim over time, the carriers may offer what we call as a Section 20 settlement. That is where they give a lump sum of money and that claim can never be opened up again within the system. The challenge we have in New Jersey is our system is designed where we pay the benefit out over weeks. So as I explained before, the arm that gets assessed at 10% and I'm paid out over 33 weeks. At the 30-week mark, my attorney may contact me to say, how are you feeling? Are you having pain in the arm? And he may reopen the claim again for what we call is additional medical, and temporary benefits. Then we go through the process again. I'll start seeking medical treatment. I may be entitled to what we call as an increased permanency award because they reassess me and now my arm is at 12.5%. So I would be entitled to 2.5% more of my arm, which on the chart would equal an additional 8.25 weeks, and I would get additional benefits. Sometimes the reopener will happen another time at the end of the 2-year mark or within that time frame. And so oftentimes if we get to 2 reopeners on a claim, the carrier may try to do a Section 20. They will only do a Section 20 when the employee is no longer within your employ. The reason we do that is it's no admission of liability. So if they injured that body part again, we couldn't take credit for the money we paid previously. So a little bit complicated, but that is it's an opportunity for the carriers to dispose of a claim if they can.
I have one here asking if you can give the website for the class codes again.
So that is NJCRIB, C-R-I-B. It's the New Jersey Compensation Rating and Inspection Bureau website.
Here's one from Rivki who asks, what is your burden of responsibility if a worker sues for a work-related injury that resulted from a no-fault accident? From what I understand, our workers' compensation insurance pays out and then goes after the other party's vehicle insurance. Can you please clarify how that works?
Certainly. So the insurance company does not go after the responsible party, but they will send what's called a lien letter. So they will send a lien letter to the responsible party to say, this injured worker is collecting workers' compensation insurance for their claim. In the event that they pursue you as the responsible party, we are putting a lien on any award that they may receive. We don't have the right to directly go against the responsible party, but they will hold out lien rights. The person on the other end that may have caused the injury, their insurance carrier, when they're settling the claim, the lien gets considered within the settlement that they're giving. So there's not a way for us to pursue it directly, but there is a way that we put a lien on any monies that may be given to the injured worker.
I have one here from Maria who asks, can you give an example of a scenario that might not be covered when a worker is injured?
So this is an area where I always tell people that it is important, whether you believe it's a scenario that it would not be covered, that it goes into the workers' comp carrier to do the full investigation and determine. I caution this area because of the simple fact that because this is a law, there are continually cases within the work comp courts that could potentially change any part of the law or compensability in certain circumstances that will be utilized. But for the most part, if the report is not, if there's missed deadlines, you didn't report the loss timely, that's one way that a claim may be denied. If an employee is under the influence, though I have had cases where people have been given compensability while under the influence, certainly that's an area that is denied. I know right now in our country with regard to the medical marijuana laws and marijuana laws that are changing, this has been a hot topic for workers' compensation. I would say that each state's going to develop its own processes, but currently if you're found to be under the influence, you are normally not entitled to comp benefits. If an injury is a result of horseplay or any kind of roughhousing or practical jokes, that's normally not something that's covered by workers' comp. But again, you have to send it in because the circumstances matter. You know, was the individual part of the horseplay or were they not? And so certainly, again, it's one of those areas that may potentially be denied, but again, the carrier should be making those decisions. You know, a condition that doesn't meet the state guidelines. So for example, in New Jersey, stress claims are non-compensable. There are some states where you could say my job stressed me out and I need to seek treatment and they are covered. In our state, stress is not a compensable. Psychological injury occasionally is picked up when it's a significant loss, you amputated your arm and now you need psychological treatment. We do pick up psychological in certain circumstances, but it's a condition that's not within the state guidelines. And then any pre-existing injury that was not aggravated by work is another area. Now, I will say there are oftentimes people ask me, well, the person had a prior back issue and now they injured their back at work. We aggravated a pre-existing condition at work. So aggravating a pre-existing condition at work is covered by workers' comp. The only time we would not cover that is if it was not an aggravation by the work.
Well, that looks like all the questions we have, so it's as good a time as any to bring things to a close. Don't forget, all of you will be receiving a recording of today's webinar and the PowerPoint slides via email. Lastly, when you close out of the webinar, a survey will come up on your screen that I hope you'll fill out so we can understand how to best provide you important information in a webinar format. Our next webinar, Succession for the New Decade, Why Now is the Best Time to Reduce Your Cost of Succession, will take place March 18th. So by all means, feel free to register for that one on our website at njbia.org/webinars. So until next time, from Meg Errickson, this is Vinny Civitello thanking you for being with us this morning and wishing you a good day.